The Zenovia Commercial Court overturns Maritime Arbitration Award relating to redelivery notice. IMT Shipping and Chartering GmbH versus Chen Sung Shipping Company Ltd. This is a shipping dispute that was initially dealt with in arbitration but subsequently appealed to the Commercial Court pursuant to Section 69 Arbitration Act 1996. Somewhat surprisingly, given the court's usual reluctance to overturn arbitration award except in extenuating circumstances in this case, Mr. Justice Tomlinson decided the arbitration award should be set aside. However, the judge did qualify his decision by indicating that he had the advantage over the tribunal of hearing oral argument from highly skilled counsel, whereas in the arbitration, oral argument had been dispensed with. Mr. Justice Tomlinson expressed the view that had the arbitrators had the benefit of hearing the oral submission put to him, they would have reached a different conclusion. The case involved a time charter in amended New York Produce Exchange form. There was a chain of charter parties as follows. The owners, CSC, time chartered the vessel to COSCO, COSCO subchartered to WBZ, WBZ sub-time chartered to IMT. These three time charterers were treated by the parties and the arbitrators as being back-to-back. The earliest and latest permissible redelivery date for the vessel were treated as being 20 September 2007 and 22 November 2007 respectively. Toward the end of the charter period, IMT subchartered the vessel to Oldendorf, who subchartered to Noble for a time charter trip. On 5 October 2007, Noble gave approximate notice of redelivery SP China on about 4 November 2007 basis AGW. The message was passed up the broker chain and the version eventually retrieved by owners gave the redelivery date as 6 November 2007. Subsequently, the charterers decided to squeeze in a further voyage before the contractual redelivery date, so they sent out a further notice to owners on 15 October saying, "We hereby revise the date of redelivery to owners to November 20 within the range of redelivery." Owners wrote back the following day saying they had already fixed the vessel for her next employment and insisted the vessel had to be redelivered at the end of a voyage to China. Charterers refused and said they had the right to use the full period given by the contract. Consequently, owners withdrew the vessel from the chartered service on 2 November, and charterers contended this was a wrongful withdrawal and claimed damage for repudiation. The parties in the contractual chain entered into an agreement to submit to the same dispute resolution process, and the matter went to arbitration before LMAA arbitrators. The arbitrators found in favor of owners. They held there were an implied term that were an approximate date of redelivery is given by charterers of a vessel. Those charterers are obliged not to do anything deliberately which prevent that approximate date being met. They also found that the acronym WP in the original notice meant without prejudice rather than the more obvious weather permitting. The arbitrators treated the meaning of without prejudice in this context as analogous to without guarantee. The acronym WOG, meaning without guarantee, was also contained in the 5 October notice, but decided that those words could not alter the effect of the 30-day notice in any event. Rather, the tribunal held that there was a promissory estoppel in favor of the owners in that they had refixed their vessel on 15 October with a laycan of 1 until 11 November, having relied on having their ship back in time for the new fixture. Appeal. The judge felt unable to tamper with the arbitrator's interpretation of WP because this aspect of their decision had not been appealed. However, he expressed concern in this regard on the ground that the word without prejudice are used in commercial communication. This is usually meant to indicate that what is being said cannot be relied on unless the parties subsequently agree that it should. On that basis, the judge said he would be reluctant to uphold a conclusion that a notice of approximate redelivery expressly given without prejudice can, without leading to an agreement, nonetheless giving rise to a promissory estoppel binding the giver of the notice. He was also reluctant to accept that a notice of approximate redelivery expressly given without prejudice generated without more on obligation on the charterer not deliberately to do anything which might prevent the approximate date given therein being met. Nonetheless, Mr. Justice Tomlinson deemed it appropriate to consider the substance of the arbitrator's argument beyond the meaning of the acronym. He pointed out that in the charter in question, there was a provision for the giving of 5 notices of approximate redelivery, followed by a further 4 notices of definite redelivery. In the judge's view, each notice had at the very least to be given honestly or in good faith. However, this didn't mean that the parties would necessarily have agreed that between the giving of a 30-day and a 20-day notice of approximate redelivery, the charterer wasn't at liberty to do anything which prevented the date first giving being met. The judge stated that the very structure of the regime providing for approximate and definite notices under the charter party militated against any argument that the parties must be bound to have agreed that the giving of the first notice as required, where it was done honestly, constrained the charterer's freedom of action thereafter. As the judge said, it was not possible to confidently assert what the parties must inevitably have agreed when they made their contract had the point been raised. As regard promissory estoppel, the judge confirmed that this required a clear and unequivocal representation by the charterer that they were giving up their strict right. In this case, their right to retain the vessel in their employment until 22 November. On the fact of this case, the defense of promissory estoppel could not succeed because the charterer said nothing from which it could reasonably be inferred that they were abandoning by contractual right. In conclusion, therefore, Mr. Justice Tomlinson found that the only decision that the arbitrators should have come to was that the totality of the word and conduct attributed to the charterers didn't make a clear and unequivocal promise to the owner either that the noble voyage would be the last employment under the charter or that they would not in the event seek to retain the vessel in their employment until the last permitted date for redelivery 22 November.